Now we're going to be talking about some frequently asked questions pertaining to the handling of public records. Number one, if I have public records in my possession and someone makes a public records request, do I have to immediately turn them over? No, the law requires that you turn the records over in a reasonable period of time. Remember though, although the term reasonable is not defined, you should not unnecessarily delay the release of records to someone requesting them. Number two, is a city allowed to require prepayment prior to releasing public records that are being requested? The answer is yes. Prepayment is sound policy as long as the fees that you're charging are allowed by Florida law. Prepayment is also good because it avoids the waste of public resources, since it helps to ensure that the requester will actually retrieve the records once they are compiled. Number three, can a city charge administrative costs for compiling records responsive to a records request, even if the time to compile those records is minimal? The answer is yes. As a recommended conservative approach, if less than 30 minutes of staff time is taken to compile the documents responsive to the request, the requester should not be charged. However, keep in mind that some courts have held that 15 minutes of preparation time is acceptable. Accordingly, the city could elect to use a 15-minute standard. In any event, applicable statutory copying charges will also apply. Number four, does the public records law apply even if the requester does not state that he or she is requesting public records? The answer is yes. A person does not have to specifically state that he or she is making a request for a public record. City personnel should treat all requests for city records as public records requests and should act in a manner that is consistent with state law and city policy. Number five, can a city require a person to sign in when making a public records request? The answer is no. Definitely not. The law is quite clear that individuals seeking public records are not required to identify themselves when requesting a public record. Number six, can a person remain anonymous when requesting a public record? The answer is yes. A person does not have to identify themselves in any way or be asked to show any identification or provide any background information whatsoever when making a public records request. Number seven, does a public records request have to be made in person? The answer is no. A public records request can be made via email, fax, a phone call, letter, or by any other means. Number eight, should records requests that are made in person be processed more quickly than records requests that are not? No. All public records requests that are made should be treated with the same level of urgency. Number nine, does a person have to indicate the reason they want a public record? The answer is no. A person does not have to provide a reason for why they are requesting public records. Number 10, is a city allowed to designate a particular person to analyze a public records request? The answer is yes. A city is allowed to designate a particular person to analyze a request in order to determine if the information requested can be released as is, or there's information in the documentation requested that should not be released. You should identify that person and forward the public records request to them. And now, for additional information, please click on the links following this video.